Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 86 of the NCDWI Guy podcast. On today's episode, we are talking about marijuana impaired driving. Marijuana impaired driving. That is the subject matter of the day. Before we dive into today's episode, I just had a cool war story to share. And this is not so much a war story as a success story, but it's just one of these things that just gives me such great joy. And I hope that everybody else gets to experience this in practice if they handle any type of DWI or traffic charges. This morning, I had two restoration hearings at the DMV. One was a early reinstatement request following a 4-year suspension. And then another one was a 4-year DWI suspension. The other one was after a permanent DWI suspension. We had our witnesses there, amazing clients, amazing group of witnesses, really some of the best witnesses that I've had on any hearing ever. And so back-to-back hearings with just stellar clients to represent stellar witnesses. And the restoration process is so interesting and rewarding in terms of helping clients get their license back, and the reactions that you get to see on your client's face when they are told by the hearing officer after the evidence is presented, after I've given my closing, that their license is going to be restored is incredibly emotional. It really just shows how important a privilege that driving is, because it is just incredibly emotional. I had a client that broke down in tears today after he has been now without a license for, I think, close to 8 years at this point. Just an incredible thing to witness the relief and pure freedom that license represents is really a powerful thing. So if you do not handle restoration hearings, you should. You absolutely should. It is one of the most rewarding things that you will do as an attorney. To me, it is my favorite part of practicing. I've said that now several times recently on the podcast. We did episode 73, which was offering some tips and pointers on helping clients get their license restored. But it really is something you should not miss out on if you do any type of DWI or traffic defense. It's not rocket science doing these hearings, but it is incredibly rewarding. You do have to be prepared. You have to have your client and your witnesses prepared. But I'm telling you, it is really one of the coolest things that you will ever do in the practice of law if you start handling some DWI restoration hearings. So just encourage you to go make that happen, because you will not regret that decision. So today we are talking about marijuana impaired driving. I had a recent case that involved marijuana impairment. And I think the fatal habit that we so often get into as defense lawyers, prosecutors fall into this trap, I think judges fall into this trap, is that if the SBI lab report shows an impairing substance in a person's system, you are dead. You're dead, right? It obviously, if it's alcohol, it comes back with a number. Well, that's not good. How do we get that suppressed at district court, right? How do we get this number suppressed? Maybe that's not still the end all be all, but obviously that's bad. If it's a illegal or prescription medication that shows up in the system, it's like, well, there's confirmation that the person is impaired. I think there is a lot of undue weight that is given to the lab report, particularly when it comes to non-alcohol impairing substances. Now, this is different for Schedule I substances, right? Because if a Schedule I shows up in the system, that effectively is somewhat proof of impairment. The fact that that is in the system is effectively in North Carolina kind of per se impairment at that point if the state is successful in proving one of those Schedule 1 substances was in the system, including proof through a lab report. But outside of that, you have to really weigh and think about what does it mean for a impairing substance to be found in your client's system by means of a lab report. And when it comes to marijuana, I think that the amount of help that lends to the case, or the amount of credibility or the amount of weight that gives to the state being able to show your client is impaired by marijuana beyond a reasonable doubt is slim. Very little help in terms of what that lab report means. If you have a lab report that comes back showing THC, THCA in your client's system, any marijuana related substance is confirmed in the lab report, that is really very little help in terms of determining whether or not your client is impaired. We'll talk about this more as I get into kind of this NHTSA report to Congress, which is going to be the focus of our conversation today. But the comparison that I think is an accurate comparison is showing that THC is in somebody's blood by means of a laboratory report is the functional equivalent of a positive on a portable breath test. That is really the comparison. It basically shows that substance was in your client's system at some time. THC was in the system at some time. We're going to talk about why THC is just meaningless if that's found in your client's system when it comes to proving impairment. Presence of that really does not do anything in terms of the state being able to show beyond a reasonable doubt that your client was impaired, and obviously particularly at the time of driving. So let's dive into this report from NHTSA, the National Highway Traffic Safety Administration. This is a report just titled Marijuana Impaired Driving. It was published in July of 2017, and it's a report to Congress. So the National Highway Traffic Safety Administration is the entity that is formulated standardized field sobriety testing, that has published, obviously, the detection of impaired drivers and a standardized field sobriety testing course that officers go through, the 24-hour NHTSA DWI enforcement course. They've come out with A-RIDE training, advanced roadside impaired driving enforcement. They've come out with the DRE program so that somebody could become a drug recognition expert, and all of the signs and clues of impairment based on different drug categories, including the drug category of cannabis, right? There's 7 drug categories. Cannabis is its own drug category. So marijuana impairment really has its own set of clues to be looking for, which is very well thought out, at least in terms of A-RIDE, DRE, the DRE program. So NHTSA has done a lot of work in terms of trying to identify clues of impairment for each of the drug categories, including cannabis. In this report to Congress, the NHTSA was really looking at specifically blood samples where there is THC identified in a person's system. How does that correlate with impairment? This is a relatively easy read. So I have it right here. This is what it looks like if you're watching the video. Green front page, easy to access online. If you just type in marijuana impaired driving into the Google, then you will get this report to pop up in PDF format, just like that. Yeah, this NHTSA report to Congress. But in terms of the value that is to be given to a THC result, NHTSA's study really shows that there isn't really any correlation between THC found in a person's blood and whether or not that person is impaired by marijuana. So we're just gonna dive in. This is a report that you could read in a relatively short period of time. I recommend reading the full report, but we're just going to look at a couple of sections of this report. And in terms of how do you get this report into evidence? Well, if you look at the hearsay exceptions under the North Carolina Rules of Evidence, North Carolina Rule 803, number 18, the learned treatise exception is Rule 803.18, and NHTSA being, the entity when it comes to standardized field sobriety testing and drug recognition, reporting to Congress in an official congressional report seems to be a pretty easy thing to satisfy in terms of this being a learned treatise. So in terms of cross-examination, it says for use on cross-examination, the treatise or pamphlet in the field of study can be used to cross-examine a expert. So it can be used to cross-examine an expert. It can be marked as an exhibit. It can be marked as an exhibit. You can ask a witness to read from sections of that learned treatise while they are sitting on the stand during cross-examination. It generally should not be admitted into evidence. So the learned treatise should not itself be generally admitted into evidence, and in a jury trial would not be allowed to be sent back into the jury room during their deliberations. So it really is for cross-examination purposes. It doesn't mean that the prosecutor could not ask follow-up questions based on what is in the treatise. But this is something that if you're trying to figure out how am I going to get this into evidence, this congressional report into evidence, all you need to do is ask the officer if they have heard of this, or if the officer indicates, well, it appears that there was THC in the blood, so that showed me that they were impaired. This treatise would say otherwise. So you could use it for purposes of impeachment, offer it based on the learned treatise exception, have the officer read from those portions of the treatise, and then again, you're not generally supposed to put that into evidence. What I would do, well, here's what I would do. Most judges are really interested in learning these issues. If you have a judge that is worth their salt, they're interested in learning these issues. And so before you ever get to a marijuana case, sometime in the next couple of weeks, take a copy of this marijuana impaired driving report to Congress, to your district court judges, and just say, I read this really interesting report recently about correlation between THC and, or really lack of correlation between THC being in somebody's blood and whether or not they're impaired. That was from NHTSA to Congress. I don't know if you'd be interested, but I've got an extra copy if you want to take a look at it. I bet you get some bites on that front. And now if you've got the judge kind of reading through that and understanding that literature, one of the best thing we can do for our district court judges is to help educate them, right? Judges don't have the time always to be spending on these issues and researching. This is a really powerful and compact report that would let a judge be informed when it comes to this topic. Give your judge the benefit of being able to read this report and digest this report before they are ever hearing it in trial. Maybe start a discussion with them, a couple of weeks later, say, hey, judge, did you have a chance to review any of that report? Pretty interesting, what's being laid out there from NHTSA to Congress. What I'm about to read is not some sort of a kind of misuse of the report. It's not as though I'm just pulling out specific sentences that are, totally the opposite of the way that the report is about to be used. But if they have read the full report, they will be able to give more trust and credibility to the specific sections that you were trying to bring out, because you obviously don't want to have a witness read 45 pages, which is the size of the report, into evidence. Your judge will probably throw you out of the courtroom and have you spinning down the hallway if you're going to waste their time like that in an actual hearing. So you've got to be selective with what you are offering to them. But what is being offered is not a misrepresentation of the report. At the same time, if a judge has read the report in full, now they can trust all of these things and say, oh yeah, that's exactly what that report says. I read the full report. Here's the things that were identified by the National Highway Traffic Safety Administration to Congress. So I'm just going to read a couple of sections from this report and then just offer a brief reflection. It is incredibly powerful because I think in a case where you have marijuana as the impairing substance, if you don't have a lot of evidence of appreciable impairment in terms of the officer's observations, the field sobriety tests that were done, whether or not an A-RIDE officer or a DRE got involved in the case, if you don't have a lot of evidence from the state of appreciable impairment, the fact that a lab report comes back positive for THC adds zero. It adds zero to the appreciable impairment case. And I just mean that straight out of this report, adds zero. So I'm just going to read several of the quotes from this report, or just several of the paragraphs. So this comes from page 8, the very top paragraph on page 8. It says THC level in blood or oral fluid does not appear to be an accurate and reliable predictor of impairment from THC. We'll say that again. THC level in the blood does not appear to be an accurate and reliable predictor of impairment from THC. Also, when low levels of THC are found in the blood, the presence of THC is not a reliable indicator of recent marijuana use. And the report goes into that. It basically says that marijuana, somebody might be impaired by marijuana for 2 or 3 hours after using, but the THC might be only in their system for a shorter period of time. And so it's not a reliable indicator of recent marijuana use, whether it appears in the blood or not. Effectively, THC is just not a reliable indicator of impairment. Further on in the report, so here at page 13, this is a pretty juicy section right here. So the middle of page 13, there is a section called feasibility of developing an impairment standard for drivers under the influence of marijuana. So here's the substantive information. Quote, currently, and I'm going to read a long quote here. I'm going to read about 2 paragraphs worth and then we'll unpack it, but I'm going to read slow. Quote, currently there is no impairment standard for drivers under the influence of marijuana. Many of the reasons for this are discussed elsewhere in this report. They include the fact that there is no chemical test for marijuana impairment, like a BAC or BRAC test for alcohol that quantifies the amount of alcohol in their body, indicates the degree of impairment and the risk of crash involvement that results from the use of alcohol. The psychoactive ingredient in marijuana, delta-9 tetrahydrocannabinol, THC, does not correlate well with impairment. While very high levels of THC do indicate recent consumption by smoking marijuana, it is very unlikely a police officer would encounter a suspect and obtain a sample of blood or oral fluid within a short enough time for high THC levels to be detected. As was mentioned earlier, impairment is observed for 2 to 3 hours after smoking, whereas by an hour after smoking, peak THC levels have declined 80 to 90%. Without a chemical test, the alternative is to develop a psychomotor, behavioral, or cognitive test that would indicate the degree of driving impairment and elevated risk of crash involvement due to marijuana use. As was described earlier in this report, marijuana has been has been shown to impair critical driving related skills, including psychomotor abilities like reaction time, tracking ability, and target detection, cognitive skills like judgment, anticipation, and divided attention, and executive functions like route planning and risk taking. However, available research does not support the development of such a psychomotor, behavioral, or cognitive test that would be practical and feasible for law enforcement to use at this time. It is certainly possible that when more research has been conducted on the impairing effects of marijuana use on driving, that can be shown to increase the risk of crash involvement, that it may be possible to develop such a test in the future. Most important thing from that section is that the psychoactive ingredient in marijuana, delta-9 tetrahydrocannabinol, THC, does not correlate well with impairment. Doesn't correlate well with impairment. This is at the bottom of page 13. It says devices capable of measuring marijuana levels in drivers. Conviction on a driving under the influence of drugs charge or evidence that marijuana played a role in a crash typically requires evidence that the driver was impaired by marijuana at the time of arrest or crash. While alcohol concentration, BAC or BRAC, is an accurate measure of alcohol impairment of driving, the presence of THC in the driver's body has not been shown to be a reliable measure of marijuana impairment of driving. So that's going to the top of page 14. And I'm going to finish or repeat that last part of the sentence that was just read there at the top of page 14. The presence of THC in the driver's body has not been shown to be a reliable measure of marijuana impairment of driving. Going on to the next paragraph, the first full paragraph on page 14, traditionally measurement of marijuana use by drivers has involved testing biological specimens for the presence of THC, typically blood samples, though urine and other substances have been used. As was stated previously, this testing can take days, weeks, or months before the results are available to law enforcement. The tests take a few hours or less to conduct, but large backlogs in many state laboratories conducting the testing can result in long delays before results are available. Such tests not only indicate whether THC was present in the sample, they also quantify the concentration or amount of THC detected, which the North Carolina Crime Lab can quantify the amount of THC. But here's the deal, and this is the last sentence on the first full paragraph of page 14. These toxicological tests confirm presence of THC, but they do not indicate driver impairment or necessarily indicate marijuana use when the THC levels are low. They confirm the presence of THC, but they do not indicate driver impairment. So regardless of whether there is a quantity present or not, the lab technician can't say just based on an or a THC level, a quantity of THC in somebody's system, if that amount of THC would cause that person impairment, would cause that person to appear impaired. No correlation like there would be with alcohol at certain levels. And obviously everybody, even with regard to alcohol, is going to show different signs of impairment depending on their drinking history, their tolerance level at a 0.08, at a 0.15, at a 0.25. A person would look different. Each person would look different in terms of the impairing effects created at that alcohol level. But there's at least some expectation of what signs and indicators you might see based on the amount of alcohol in somebody's system. Not so with THC. These toxicological tests confirm presence of THC, but they do not indicate driver impairment or necessarily indicate recent marijuana use. This is at the bottom of page 27. Bottom of page 27. This is the last paragraph at the bottom of page 27. As the previous sections of this report have indicated, the poor correlation of THC level in the blood or oral fluid with impairment precludes using THC blood or oral fluid levels as an indicator of driver impairment. This is so critical. This paragraph is so critical in distinguishing between what does it mean when there is a quantity of alcohol in a blood test versus what is the quantity of THC in somebody's blood test. Pay close attention to this. This is kind of the whole report in a nutshell. So get ready for this. As the previous sections of this report have indicated, the poor correlation of THC level in the blood or oral fluid with impairment precludes using THC blood or oral fluid levels as an indicator of driver impairment. The use of BAC or BRAC as an indicator of driving impairment has assisted law enforcement and prosecutors in being able to show that an alcohol impaired driver has a BAC that has been demonstrated to increase crash risk. The use of THC level cannot serve this same role for marijuana impaired driving. And then it references a couple of different studies that were done in 2012. Toxicologists are not able to provide expert testimony that a specific amount of THC present in the suspect's blood or other specimen is definitively associated with being impaired by marijuana and render the driver unable to drive safely. Read that again. Again, whether you have an officer on the stand, a toxicologist on the stand, this is the end all be all. And I honestly don't think any toxicologist worth their salt from the SBI lab would disagree with this, because I've actually talked to several toxicologists from the SBI lab in the past that have said, yeah, we could not, from just knowing a suspect's THC level, be able to determine what their appearance would look like, if they would be showing signs of impairment in their activities. So I think that you have a toxicologist with their salt, they would do nothing but affirm this. But this is so powerful. Toxicologists, this is at the top of page 28, very first sentence at the top of page 28 of the report. Toxicologists are not able to provide expert testimony that a specific amount of THC present in a suspect's blood or other specimen is definitively associated with being impaired by marijuana and render the driver unable to drive safely. Boom. I mean, boom, right there. I mean, that is basically saying THC being in the blood, meaningless. Even if you have a quantity of how much THC is in a person's blood, meaningless when it comes to proving impairment. Now, if you have a driving after consuming being less than 21 charge, maybe you got a problem here, because if they're able to show presence of an impairing substance in your client's system, that's a problem. That's really the element that is necessary to prove in a driving after consuming case. But if you are talking about DWI, driving while impaired, whether or not the person is actually impaired by the impairing substance, this sentence that I just read effectively says THC being in the blood, even with a quantity attached to it, is meaningless in being able to determine whether a person is impaired or there was enough marijuana use to render a person unsafe to drive. The blood doesn't matter. What matters is how did your client look, walk, talk? How did he do on field sobriety tests? How was he in response to officer questions? And maybe bad, right? I mean, maybe you have a really bad video, in which case probably going to have a hard time winning that case. But if you have a client that looks normal or within the spectrum of normal in terms of their interaction with the officer, and the state has got a high burden of proof beyond a reasonable doubt that they're impaired, what you want to be very clear about, and what I think we're not arguing enough as a defense bar, is the lab report in a marijuana case proving there's THC in the system is completely worthless when it comes to evaluating whether or not somebody's impaired. It is effectively the exact same as a positive on a PBT. It shows the presence, but it has nothing to do with whether or not the person is impaired. You cannot imagine in a case the state basically saying, well, yeah, this person didn't have slurred speech. They didn't have any problems walking around. They showed a couple of clues on the walk and turn, but really none on the one leg stand. And the HGN was kind of inconclusive. But judge, there was a positive on the PBT. There was a positive on the PBT, so you must convict. But a lot of times that really is the selling point or the attitude when it comes to marijuana cases. The state will point to that THC and say, judge, look what came back in the report. Well, yeah, if they were smoking marijuana, it's probably going to be THC in the system. That is proof of presence, just like a PBT is proof of presence of alcohol, but it has nothing to do with proof of impairment. And the fact that in a BAC case, in a alcohol case, you can get a level that does have meaning because of our per se limit in North Carolina, no corresponding limit, per se limit in North Carolina. And here's the reason why hopefully North Carolina won't go in that direction. So here is in the middle of page 28. A number of states have set a THC limit in their laws, indicating that if a suspect's THC concentration is above that level, typically 5 nanograms per milliliter of blood, then the suspect is to be considered impaired. All right, get ready for this. This per se limit appears to have been based on something other than scientific evidence. I want to read that again. This per se limit of 5 nanograms of marijuana or 5 nanograms of THC per milliliter of blood, this per se limit appears to have been based on something other than scientific evidence. Some recent studies demonstrate that such per se limits are not evidence-based. Okay, so hopefully we don't get a per se limit in North Carolina because it seems absurd to criminally punish people based on a scientific test that does not give us scientific evidence, right? I mean, it just doesn't make sense. So again, this is just coming straight out of the NHTSA report. I will end with this, but again, there's all kinds of nuggets in this thing. If we're only as a defense bar going to have to defend more and more marijuana impaired driving cases. At some point, the legalization of marijuana for medicinal use, for recreational use, is growing. It's not shrinking in every state. It's going to become more and more widespread, more and more available. And that ultimately means that there's going to be more and more charges for driving while impaired related to marijuana. Once it's legalized, that would be what I would expect to see as an increase of charges related to that. So I will finish with this. This is coming from the 2 middle paragraphs on page 29 of the report. Another recent study conducted using Washington state data was designed to examine whether the concentration of THC in a driver's blood was a reliable indicator of impairment. This study used 602 drivers arrested for impaired driving in which only THC was detected, with a sample of 349 drug-free control drivers, for which the subject's performance in the DRE exam were available. Results showed significant differences in the THC positive and negative drivers in terms of poor performance on the psychophysical test, walk and turn, one leg stand, finger to nose, along with indicators like red bloodshot and watery eyes, eyelid tremor, lack of convergence, and rebound dilation. Having found differences between THC positive and THC negative drivers, the relationship between THC concentration and performance on tests for impairment was examined. And here's the kicker. Here's the kicker from the report. Last sentence of that paragraph. Poor correlation between THC concentration and performance was found, which again indicates that blood THC level is not a reliable indicator of impairment. Blood THC level is not a reliable indicator of impairment. Finally, an assessment of whether the combination of the physiological, cognitive, and psychomotor indicators could reliably predict whether the driver's THC concentration was above or below 5 nanograms per milliliter threshold was conducted. No differences were found except for the finger to nose test. Some individual signs, symptoms, and tests had weak correlations with the THC concentration being above or below the threshold, but none of them met basic sensitivity levels for correctly predicting impairment status. The conclusion of the study was that, quote, there is no evidence from the data collected, particularly from the subjects assessed through the DRE exam, that any objective threshold exists that establish impairment based on THC concentrations in suspects placed under arrest for impaired driving, end quote. So in these case studies where there was lab reports that came back THC positive and THC negative, there was no good correlation between whether somebody appeared impaired by the marijuana and those THC levels, or basically whether there's a positive or a negative. Again, poor correlation between THC concentration and performance was found, which again indicates that blood THC level is not a reliable indicator of impairment. So at the end of the day, a marijuana impaired driving case rests on whether or not there is actual evidence of your client being appreciably impaired. It's based on whether or not your client was appreciably impaired. We wait months, sometimes a year plus, for these blood results to come back, which tell us nothing. And maybe it's because they take so long to come back that we almost put so much weight into them. I don't really know why there is so much weight going into what is there THC in the blood, and what was the quantity? Because this report, and I think any analyst that would come in and testify on this, and so this might kind of play into your strategy, call a lab analyst the next time you get a report back and ask them these questions. Call the lab analyst that was involved and say, I got this report, I represent this guy. Tell me, based on the THC that was found in my client's system, would you be able to determine based on that clue alone, on that quantity alone, whether or not a person would appear impaired? And I think they're going to tell you no. So again, this might weigh into whether or not you might want that lab analyst to have to come in and testify. They might be a defense-friendly witness on a THC case because the lab itself is not helpful in determining whether or not somebody is appreciably impaired by marijuana. Don't let too much weight be given to the lab. Use this report from the National Highway Traffic Safety Administration to Congress to show that there is no good correlation that exists between THC, even in a specific quantity, being found in your client's blood and whether or not your client was actually impaired by marijuana. It's got to be based on the driving, got to be based on the personal contact, the physical signs and indicators of impairment that are present or not, and it's got to be based on the field sobriety tests. And ultimately, at the end of the day, if the state, based on all of those things and whether there was a DRE involved and what was the extent of the investigation and how much training did this officer have in detecting non-alcohol related impairment, based on all of that, that is where the state is going to have to move in terms of showing that your client was appreciably impaired by marijuana. Educate your bench, educate your judges. They need us to help on that front. They don't have the time to go out and do all the digging. They don't have all the time to go out and do all the research. Don't let a lack of knowledge prevent justice from being done in the courtroom. And if there's too much weight given to the result of a positive THC finding in your client's blood in an SBI lab report, if there's too much weight given to that, justice is not being done in the courtroom. So do your homework and then pass your findings along to your bench. Look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you're listening on, I would greatly appreciate it.